Hola, mi nombre es Ileana Zúñiga y el día de hoy vamos a tener a Anna Keegan, que es la directora de Renta Justa de la ciudad de Norwalk, y ella nos estará dando información de cómo protegernos y defendernos en contra de la gente que quiere abusar de nosotros con respecto a nuestra renta de casa o departamento. Es muy interesante y quédense con nosotros.
Hi, I'm Anna Keegan. I'm the acting director of the Norwalk Human Relations and Fair Rent Department. I'm going to be talking about a number of issues, trying to go through some of the main issues that tenants face, especially in these days, including the eviction moratoria. However, I want to start off by saying that none of this is comprehensive, and if you have any issues, please, please, please don't just watch this. Call our office. We are available at 203-854-7989. You can call in any language and request a translator, and we will get back to you. Our admin speaks Spanish, but any language we will get back to you with a translator if needed. So please, if you have an issue, call us before you do something rather than after you do something. The sooner you call, the more options you tend to have. So that said, I'm going to start off by talking a little bit about the process of finding housing. Because when you're looking for an apartment, that is your best chance to avoid a bad situation. So for one, pay attention to your instincts, because the way people treat you when you're first looking for an apartment is the best they are ever going to treat you. You should also know that there's so if someone behaves badly at the beginning, don't expect it to get better because it's a cheap apartment. It may not, and it's probably going to get worse. So pay attention to instincts right at the start, because that's your best chance to get away before you've moved in. Now, when you're looking for an apartment, it is important to know that it is illegal for landlords to discriminate against you based on your membership in a protected class. So what country you're from, your race, your ethnicity, they cannot ask about your they can ask about your documentation status, but they can't refuse to rent to you because of it. They also can't refuse to rent to you because you have a family, or say you need so many bedrooms for children if you want to have children. If any of those issues happen in Norwalk, you should call Margaret Sueb, the Fair Housing Officer who deals with housing discrimination. Her number is 203-854-7820. If it happens outside of Norwalk, then you should call the Connecticut Fair Housing Center. I don't have their number off the top of my head, but they're also an excellent resource for
y ellos
dealing
también
with housing
podrán
discrimination.
ayudarle cómo
Now,
manejar
once you
estos casos
find
de
an
discriminación.
apartment,
Una vez que ya encuentran un
the first thing
departamento,
you
la
generally are
primera
going to do,
cosa que
sometimes
van
at
a
least,
hacer
is sign a
es
lease. If
firmar
your
un
landlord
contrato.
does not bring an extra
Si
copy of
su
the lease
casero
for
no
you
le
to
trae
take
una
with
copia
you,
extra del
you take
contrato
out
para
your
que se la
phone
quede,
and you take a
usted saca un
picture of
teléfono y
every
le
single
saca
page
una
of the
foto a cada
lease,
página del
and then you
contrato.
sign and
Y
you take a
entonces lo
picture of the
firma
page with
y
the
le
signature
saca
on it.
una foto a todo lo que ya
You
esté
never,
firmado.
ever, ever
Nunca
let yourself go away
deje
without some
que
record
el
of the
casero
lease,
no le
because there's
entregue un
no law
récord
that
del
says the
contrato.
landlord has to give you a copy
El
later. So you
rentero
make
siempre
sure you
debe
have a
darle
copy
una
now.
copia del contrato, es que asegúrese que tenga una
Some
copia.
lease terms you should be aware of. The
Algunas cosas que
security
debe
deposit.
considerar
A
es el
security
seguro,
deposit
el
is not
depósito
allowed
de
to be more
seguro.
than 2 months
No
rent.
puede ser más de 2 meses de renta.
If you are over 62,
Si
the
tiene más de
security deposit is not
62
allowed to
años,
be more than 1 month's rent.
no es permitido que le cobren más de un mes
Last
de
month's
renta.
rent is considered part of the security deposit. So if the landlord wants you to pay last month's rent, that means they can charge 1 month security and 1 month last month's rent. They cannot charge you 2 months security and also charge you a last month's rent. The law is very, very clear on that and very simple. And if you have any issues finding it, call our office. Once you move into the place, before you start moving your things in, take a lot of pictures of the apartment. Go through every room, take a wide picture of the room, and then take pictures of specifics in the room. The reason why you want to do that is it establishes a before and after. So if the time comes for you to move out and your landlord is saying you caused damage, but actually that damage was there to begin with, you'll have the pictures right there in order to show, no, this damage was here when I moved in. Likewise, when you take out, whether you do a walkthrough or not, whether your landlord says, yes, everything's fine, I'm going to return your security or deposit or not, you take a lot of pictures just in case. Plenty of landlords have done walkthroughs and said everything's fine, then changed their mind the next day. You always want to have pictures. Pictures are better than a walkthrough. Now, when you sign a lease, you've got various lease terms in it. One of them is paying rent. If you pay rent in cash, the law says the landlord is required to give you a receipt. Some landlords don't do that. So if you are ready to pay rent and all you've got is cash, or your landlord is demanding cash and your landlord does not have a receipt on hand, you write up your own receipt and make your landlord sign it, saying that you gave them this much money on this date for the rent of this month, and then you have the landlord sign it before you give them cash. Don't ever pay cash without getting a receipt. It puts you in a really bad position if your landlord tries to do something dishonest later. And the law is very clear that the landlord is required to give you a receipt. Another common lease term is the issue of late fees. A landlord cannot charge a late fee before the expiration of the 9-day grace period if you pay rent every month. So if your rent is due on the 1st and you pay rent by the 10th, the landlord can't charge you a late fee. It doesn't matter if the lease says otherwise. Lots of leases say after 5 days they can charge a late fee. That doesn't matter. The law overrides the lease in this case. So no late fees can be charged before the 10th of the month. Late fees also can't be constantly accruing. There's a limit on how much late fees the landlord can charge, and the case law varies. It's somewhere between 5 to 8% of the total rent, but no more than that. So a $5 a day late fee might be okay up to 5% of the rent, but after that, they may not be able to charge it at all. So even if your lease has a really exorbitant late fee, understand that the law does not allow really exorbitant late fees. It allows late fees up to 5 to 8% of the rent, and that depends kind of on the judge in the case. There's some bills that have been going forward to try and make that more specific, but no new laws as of yet. However, we'd like to keep our eyes peeled in case we get some laws that make that more specific and better, because that would work out better for everyone. Another common lease term that you're going to be dealing with is the question of utilities. If utilities are separately metered for your use only, then you can be made to pay for utilities. However, if there is anything on your meter that is not separately metered for your apartment only, a shared washer in the basement, the lights in a common area, the downstairs whatever, if you're in an upstairs apartment, the landlord cannot make you pay for the utilities at all. If there is anything on your meter that is not separately metered for your use only, it is the landlord's responsibility to pay for all of the utilities. They can't write something in the lease that says you pay for half of the bill and the downstairs pays for half. That is also illegal. If it's not separately metered, you're paying only for what you actually use. Then the law says the landlord has to pay for all of it. If you have trouble with that, and a lot of people do, the first call is usually to the health department. The health department can come out, and if they find that there's stuff on your meter that shouldn't be, they can order the landlord to put the whole bill in their name. Yeah, the number for the health department is 203-854-7776. They're a wonderful resource. You can also file a fair rent complaint saying that if the landlord is trying to make you pay for the utilities that aren't in your name, at least in Norwalk you can, then it makes your rent unfair. What happens when you file a fair rent complaint is something I'll get into a little bit later when I get into rent increases. Now, according to the lease, often leases will say that landlords are allowed to come in to do inspections whenever they want. That's kind of true and kind of not. The law says that a landlord cannot come into your apartment without your permission except in an emergency situation like a fire or a pipe burst, something that requires immediate action. If it's not an emergency situation, no matter what your lease says, your landlord can't just march into your apartment. They're required to give you reasonable notice, which means at least 24 hours notice, and you can say no. If you say no, however, you are required to provide the landlord reasonable access at reasonable times with reasonable notice. So what I usually tell people is if you say no to a specific time, provide the landlord 3 other times when you are available. If the landlord tries to come into your apartment without your permission in a non-emergency situation, call the police. It's criminal trespass. The police in Norwalk are aware of this, and the police in Norwalk will never ask about documentation status, nor will any Norwalk City department. Your documentation status is completely irrelevant to your rights as a tenant. And if the landlord tries to come in or threatens to call ICE or whatever else they do, you can still call the police and it will be okay. They know the law is the landlord cannot come in without your permission. If your landlord tries to shut off your utilities, which is a thing they sometimes do, if it's during the weekday, call the health department. If it's during the evening or the weekend, you call the police. It is illegal criminal lockout, and the police can take care of it and the health department can take care of it, and both of them are pretty good, at least in Norwalk. Now, a lot of people worry about calling the health department or calling the police. They worry that if they call the health department because their landlord isn't fixing things, which is the solution. If your landlord is not making important repairs, you call the health department. They're worried that if they do that, their landlord's going to evict them. There's a law that says if your landlord begins an eviction within 6 months of you asking for an important repair or going to any city department regarding a complaint about the housing, and that does include the police as well as the health department and fair rent, then it's presumed that the landlord is trying to retaliate against you, and the landlord is not allowed to begin the eviction within 6 months except for one of 4 reasons. If you don't pay rent, if the landlord asks you to leave prior to you filing the complaint, and asks you to leave means they have to have given you legal paperwork such as a notice to quit. It can't just be a letter saying, hey, either pay this rent increase or move out. It has to be unequivocal and formal. If you're using the apartment for an illegal purpose or a purpose in violation of the lease, this is usually things like using the apartment for illegal sex work or the sale of drugs or other illegal purposes. It doesn't happen too often. Or if the landlord wants to live in the apartment for their own home in good faith. Other than those 4 reasons, if the landlord tries to begin an eviction, then it is considered retaliatory and they won't be able to get very far. And I'll discuss that a little bit more when I get into evictions. Now, oftentimes you have the question that comes up where a landlord wants to increase the rent. That also can happen with repairs, actually, where a tenant asks for a repair and the landlord says, you called the health department out, so I'm going to make the repair, but I'm increasing your rent. The law against retaliation also says that the landlord cannot increase the rent within 6 months, or it will be considered retaliatory, unless the landlord is liable for a substantial increase in costs not related to the repair, and the rent increase is prorated across all the landlord's tenants just to cover the amount of the increase in costs. This would be things like if their taxes suddenly went up a lot, and even then the increase could only be for the amount of the increase in taxes prorated across all the apartments in the building. Now, anytime you've got a rent increase, if you're a tenant in the city of Norwalk, if you think that increase is unfair, or if you lose services that were previously included in the rent and you think that makes your rent unfair, or the landlord isn't making repairs and you think that makes the rent unfair, you also have the right to file a fair rent complaint with our office. What happens when you file a fair rent complaint is first, during not COVID, someone goes out to inspect your apartment and take pictures. During COVID, that is not happening for everyone's safety, but hopefully we'll be getting safer soon. After that, then our office will contact the landlord to let them know both that you have filed the complaint and also that they are not allowed to begin evictions and that you are protected against retaliation. You will be instructed to keep paying the last agreed upon rent and to set aside the amount of the difference. So if it is a case of a rent increase, you want to file the complaint before you pay the rent increase. Because once you've paid the rent increase once, that's the last agreed upon rent, and you'll continue paying it throughout the course of the complaint until you reach an agreement as to what the rent should be. You'll still have the right to file a fair rent complaint even if you've paid the rent increase, but what will change is how much rent you pay during the course of the fair rent complaint until an agreement is reached. What happens after that is the department works with the landlord and the tenant to try and work out a settlement agreement. That's actually an incredibly flexible process, and I think one of the best things about a fair rent complaint is that we work with the landlord and the tenant to try and work out a settlement agreement, which can be anything the landlord and the tenant can agree to. So if a tenant would prefer to break a lease and move out rather than continue dealing with the landlord and repair issues, that can be part of a settlement agreement. If they want an agreement about repairs before they agree to a rent increase, that can be part of a settlement agreement. We once had a settlement agreement where they agreed about where bird seed should be kept on the premises. Just to give you an idea of how flexible the process is, an agreement about security deposit returns is also a common settlement agreement. It doesn't just have to be about the rent, although, of course, the amount of the rent is also a very common settlement agreement. Usually that process works out. About 90% of our cases reach a settlement agreement. During the course of the settlement agreement, if the tenant prefers not to talk to the landlord directly or the landlord prefers not to talk to the tenant directly, everyone has the option of negotiating through our office rather than addressing each other directly. Sometimes that can be very helpful, especially in a situation where things have reached an abusive or yelly level. It can be comforting to know that there's going to be a go-between person so you don't have to deal with it directly. Also, so you'll have a little bit of time to think without all the pressure. If a case cannot reach a settlement agreement, which as I said, 90% of our cases do, it can go to a hearing before the Fair Rent Commission. The Fair Rent Commission, you don't have to have a lawyer. Most of our cases, they don't have lawyers. And also, if you need a translator, you can let the department know and a translator will be provided at the hearing. The Fair Rent Commission looks at a list of 13 factors to decide if a rent increase is fair or unfair. They look at things like what's being charged for similar apartments in similar neighborhoods, how big the rooms are, how many rooms there are, what utilities and amenities are included, what repairs are needed, if you caused any damage to the apartment. Your income is a factor, as is the landlord's expenses, as is the extent to which the landlord will use the increase to reinvest in the property. Based on all those factors, the Fair Rent Commission at a hearing will decide what the rent should be. If they find health code violations, they can also order rent paid into escrow to the commission until repairs are made. So you would still be paying rent, but the landlord wouldn't get the money until they had made the repairs ordered by the commission, which can be a useful incentive to landlords to make repairs. Whatever the Fair Rent Commission orders to be paid, that's what the rent will be. There's not a lot of negotiating. Appeals are possible, but it's only over if the Fair Rent Commission made a mistake of law. Their findings of fact are not considered appealable unless it's a gross error. If during the course of a fair rent complaint, a landlord tries to begin an eviction or take other retaliatory action, there's a separate fair rent retaliation complaint form. A tenant can file a retaliation complaint with the Fair Rent Commission if they've already filed a fair rent complaint, and the Fair Rent Commission, if the landlord won't stop the retaliation after the complaint is filed, can also hold a hearing and order the landlord to cease and desist either the eviction or any other retaliatory action. So we both have the usual protections and also a process with which to handle them, which can be very useful because it means you don't even have to get to the point in eviction that you would in other cases. So that's the fair rent process. I think I've discussed most of the things that will happen while living there that I want to get to before going on to eviction. So let's talk about move out and abandonment, and then I'll move on to eviction. So when you're moving out of an apartment, I said to take pictures when you first move in. You should also take pictures after you've moved out all your things. As I said before, pictures are better than a walkthrough. Even if you do a walkthrough and the landlord says everything's great, take pictures anyway, and take a lot of them. The best way to organize pictures is one wide picture of the room and then all the details in the room before going on to the next room. That way, for each set of pictures, you know what room it was in. And that makes it easier for other people to see, like judges, if you end up having to go to small claims court. The next thing you'll do is you will send your landlord a letter using priority mail, which has mail tracking, but the landlord doesn't have to sign to receive it. In the letter, which you'll keep a copy of for yourself, you need to say, I moved out on this date. Please return my security deposit of this amount plus interest to me at this address, and give an address. You don't have to give your address. You can give a friend's address or a work address or a P.O. box if you don't want the landlord to have your new address, but you have to give an address and probably one that you can actually get mail at. The landlord has 30 days from the day you move out or 15 days from the day they get the letter, whichever one is later, so send the letter early, to either return your deposit or send you a letter accounting for damages. That would be a letter saying something like, this is how much your security deposit is, this is how much interest it accrued, this is the rent you didn't pay, these are the damages beyond ordinary wear and tear you caused to the apartment, here's a check for the remainder. If they don't do one of those two things within that 30-day timeline, you can take the landlord to small claims court and sue them for twice the security deposit, automatic double damages, which is why it's so important you send that letter. Because if you're going to end up suing them anyway, sue them for twice the damages is better, and also a good reason for them to settle and just give you your security deposit back. So let's talk about what damages a landlord can and can't charge you for. A landlord cannot charge you for ordinary wear and tear, which means the sort of damage that you expect from someone, a normal person living in an apartment normally. You expect the carpet to be kind of worn down and a little dirtier around the door. You expect the paint not to be new after 7 years of someone living there. You expect people to hang pictures, so you expect small nail holes in the wall. Those are all ordinary wear and tear. You don't expect fist holes in the wall, blood stains on the carpet. That was a dramatic example. You don't expect major damages is the point. So if it is something that it's clear is caused by the tenant, then it is something that the tenant is responsible to pay for. The story doesn't stop there though. For instance, going back to my wine-stained carpet, which is the less dramatic example, if the carpet is not new, then the landlord can't necessarily charge you for the cost of a new carpet. They can charge you for the remaining value of the old carpet. So if it was a carpet that was supposed to last 10 years and it's been there for 7 years, the landlord would be unjustly benefiting if they got a brand new carpet out of it. So what they can charge you for is the remaining 3 years of the carpet, not necessarily for a brand new one. So if you get an accounting for damages that you don't agree with, and you end up having to take the landlord to small claims court to sue them for the security, bring up these issues that even if it is a legitimate claim, the landlord may be overcharging for the legitimate claim. You can dispute not just the claim, but also how much the claim is. And it's important to do both, because a giant charge for something that isn't worth that much, that's not a legitimate claim, and you need to bring that up so that the judge can know that. In any case where you don't agree with the landlord's charges, you take them to small claims court. There's a $95 filing fee. If you can't afford that fee, then you can apply for an application fee waiver and get the fee waived if the court believes it's appropriate. If you win, you can get that money back as well as the receipts for all your mailing costs. So keep track of all the mailing that you do for the small claims case. Priority mail is acceptable service for small claims, even though it isn't in other ways. So I often tell people to try and use priority mail because if they use certified mail to serve the landlord and the landlord doesn't sign for it, it gets sent back to the tenant, which is a hassle. If you use priority mail, you still get the mail tracking, but it just gets dropped off. So it's a little bit easier. This isn't acceptable in other court settings, but it is for small claims courts, so take advantage of that. And again, all these things that I've talked about, anytime you're hitting an issue with this, I am just running through the motions on these. There's a lot more detail to happen. So again, please call our office if you have any questions about any of these things happening. You can get a lot more specific guidance, and we really prefer people call us more rather than less, because this is just a very basic training. So that's if you move out of your own accord. What if you have a lease and you want to get out of the lease before the end of the lease? Well, that's kind of difficult to do. If the landlord is doing something so serious that it breaks the lease terms, then you can send the landlord a letter listing the things they're doing that break the lease terms, and it has to be something pretty serious. And saying that the landlord has 15 days to fix those things, or else you will terminate the lease and move out at X date, and the date you set has to be within 30 days of you sending the letter. It's a very short timeline. It's very hard for most people to work, but that is one option to terminate the lease. Most landlords won't actually accept that sort of termination, and you'll probably be in for a fight for your security deposit. So if you do that, plan ahead for that fight as well, and not having that money immediately. Otherwise, the law says that if a tenant moves out before the lease is done, the landlord has a duty to try and mitigate their damages by making reasonable efforts to try and find a new tenant. If the landlord does not make reasonable efforts to try and find a new tenant, you don't have to pay rent after you move out. If the landlord does try and find a new tenant but can't, then you have to pay rent, or you're liable for rent. They can sue you for it, either until the end of the lease or until they find a new tenant, whichever one comes first. So if, for instance, you find a new tenant and you present that tenant to the landlord, who is equally well qualified to you, and the landlord refuses to rent to them, you have a fairly good argument that the landlord refused to mitigate their damages by refusing to rent to this new tenant, and you may not have to end up owing them anything at all. Keep documentation. The way I tell people to document whether the landlord is trying to mitigate their damages is to look up whether the landlord's placed ads, because usually you found the apartment through an ad placed somewhere, so check that same place to see if the landlord has put the ads up. And the landlord should begin looking as soon as they know you're leaving, not wait till after you move out to start that process. So if you tell them a month in advance that you're breaking the lease and moving out, that's when they should start advertising. If they don't, you have a fairly good argument that they haven't mitigated their damages. So that is all the positive stuff. I've saved the most negative for last, and that is eviction. So for starters, let's talk about things landlords can't do. Landlords cannot change the locks, throw your stuff out, turn off your utilities, harass you day and night. If the landlord tries to do any of those things, you call the police. It is illegal self-help eviction for the landlord to try and do any of those things, and the police know that and will tell the landlord to cut it out. As I've said before, the police do not care about anyone's documentation status. Documentation status is not relevant to your rights as a tenant, which means you can call the police if the landlord is trying to do any of these things, and the police will stop them. The landlord is required to go through a full court eviction process, the same as anyone else. Now, some landlords say they're going to call ICE as well. I
A
would
veces los
recommend
caseros os
talking to the
amenazarán
Connecticut
con llamarle a ICE.
Institute,
Lo que les
the
recomiendo
Connecticut
es que
Institute on
hablen con el
Refugees and
Instituto de
Immigrants
Connecticut
for
para
a
la
full
ayuda a
notoriety on
refugiados
that.
e
I'm just
inmigrantes
briefly going to cover a few
para
things.
que aprendan
One,
cuáles
I'm
son
not
todos
sure
sus
ICE comes out
derechos.
because a
Yo
landlord
solamente
calls
quiero
and says
cubrir
my
algunas
tenant's
cosas.
there.
Uno,
Two,
si
if
a él
ICE
llega a
does
su
come
casa
out,
porque le
they are
habla
not
el
allowed to
casero,
enter an apartment without a warrant signed by a judge. ICE has done this thing in the past where they write warrant on the top of the paper and claim it's a warrant when it is not a real warrant signed by a judge. It has to be a real warrant actually signed by a judge before you are required to open the door to ICE. If you do not open the door to ICE and they do not have a warrant, there is nothing they can do. If they say they have a warrant, have them slide it under the door so you can examine it without unlocking the door. You're also not required to talk to them or tell them your name or give them any information like that. The right to remain silent is in effect. More details about this, I would really recommend the Connecticut Institute for Refugees and Immigrants. I just want to briefly cover that point because even if ICE were called and were to come out to an individual apartment on a landlord's say-so, which I think is much less likely under this administration, that doesn't mean that you have to open the door. And in order to get a warrant signed by a judge, that takes a little bit more evidence. So let's talk about the actual eviction process. The first step in an eviction process is you get served with the notice to quit. This is usually left stuffed in the door jamb or under the door. I get a lot of questions about whether or not that's legal. Yes, it is. The notice to quit usually lists the reasons for eviction. Now, before I get into that, I want to talk about right now, no notices to quit can be served except for 4 reasons because we are under an eviction moratorium until April 20th. Governor Lamont's eviction moratorium says no evictions are allowed to go forward unless a tenant owes more than 6 months rent, unless the tenant owed rent as of February 29th, 2020, last year, for serious nuisance, which means illegal sex work, sale of drugs in the apartment, or threatening the landlord or the other tenants with serious injury, or, actually causing it. Or if the landlord in good faith wants to live there for their own home. For no other reason can the landlord begin an eviction, including serving you a notice to quit, until April 20th. There is also a CDC moratorium, which I got an email this morning, that has been extended until June 30th. The CDC moratorium is a little bit more restrictive. The CDC eviction moratorium requires you to sign a declaration form and return it to your landlord, signed by every adult in the household. The declaration form has to say that you make less than $99,000 a year. That should be fairly simple. That you have lost income due to COVID, either due to lost wages, lost jobs if you're an independent contractor, or medical costs that are more than 7.5% of your expected annual income. That you've tried to make partial rent payments. That if evicted, you are likely to become homeless or have to live with another family, and that you understand all the rent is still due. If everyone in the household signs this declaration form and gives it back to the landlord, then the landlord cannot begin an eviction for non-payment of rent until June 30th. So that just came up today. I have not read in greater detail about it. It used to be until March 31st. It is now until June 30th. If a tenant has already given the landlord the declaration form, don't worry about it, you're already covered. If you get an eviction, a notice to quit under Governor Lamont's executive order, it will probably have a copy of this declaration form attached. So if the tenant is being evicted for owing more than 6 months rent, for instance, they can still be protected by the CDC eviction moratorium as long as they sign the declaration form and get it to the landlord. Because the CDC eviction moratorium doesn't care how much rent you owe. You're protected from eviction for non-payment of rent as long as all the other things on the form are true. So those are the two moratoria and how they interact. Once you get a notice to quit, it'll list the reasons for the eviction. It will also usually contain language, something along the lines of, future rent payments will be accepted for use and occupancy only with a full reservation of rights to continue with the eviction action. The key words you want to look for are use and occupancy. What that means is, if you pay rent after receiving the notice to quit, the landlord can take your money and still evict you. So if you get a notice to quit, then you want to pay rent and, end the eviction. You need something in writing signed by your landlord saying that you are now a tenant in good standing again to get past that use and occupancy language. You can't just pay them the rent and expect the eviction to go away if you've gotten a notice to quit with that use and occupancy language on it. So hang on to your money unless you've got good reason. That doesn't mean that there won't be an opportunity later to work things out. It just means that you can't pay rent and expect it to go away without signed stuff from your landlord. Once you've been served a notice to quit, it usually gives you a minimum of 5 days to get out. A lot of tenants get this and freak out and think they have to be out in 5 days. That is absolutely 100% not the case. If you get a notice to quit and you are not out in 5 days, absolutely nothing happens except more paperwork. So if you get a notice to quit, do not think that you have to be out in 5 days. You don't. And if the landlord thinks that it means that and tries any of those self-help eviction things, call the police, you're fine. The next step, if you're not out in those 5 days, and most people won't be, is that you'll get another set of papers stuffed in your door. This will be a summons and complaint. On the top right-hand corner of that, there'll be a return date. By that day or 2 days after, you need to go to court and file an appearance and an answer. The answer form is actually pretty easy to deal with once you know what you're dealing with. You first have to, at the top of the form, agree, disagree, or say that you don't know for each of the numbered things in the landlord's complaint, which will be the form you'll have gotten stuffed in your door. After that, the answer form has a whole list of defenses. It tries to have most of the defenses that you would need listed on the form. So you go through each of those defenses and you check off the ones that apply. For instance, in a non-payment of rent eviction, you may not owe rent if there are such serious repair issues that it renders the apartment uninhabitable. Now, I wouldn't recommend stopping paying rent because of repair issues. That's a good way to get an eviction started, and the more you can stay out of eviction court, the better. Go to the health department if you have repair issues. But if you're already in the eviction, check, and you have serious repair issues, there's roaches, there's mice, there's all sorts of gross, creepy crawlies, check that off and list the issues. Get the health department out if you haven't already, because the health department report can be useful evidence in court. That retaliation protection I talked about before, that the landlord can't begin an eviction against you if you've been to the health department or filed a fair rent complaint, there's a checkbox for that. Check it off, say what department you went to and what they did, and get copies of their forms. They won't give them to you unless you ask, but if you ask, you can always get a copy of whatever the health department sent out. Sorry, that's a lot of talking there. So you want to go through each of the list of defenses and check off any of them that apply. Once you've done that, then you will file the paperwork and then you'll get a court date. We've been hearing of incidences where people get mailed the court date, but they don't get the mail until after the court date. Mail is not reliable right now. So I really recommend everyone make a practice of checking on the judicial court website to see if they have a court date listed. It's not that hard. The court website is JUD, J as in Juliet, U as in underwater, D as in dog, .ct, C as in cat, T as in Tom, .gov. And there's a thing where you can do case lookup, and you just look up your own name. And then I find it easiest to sort by housing, by what geographic area you're in. So if I'm looking for a Norwalk case, I'll just look down until I see Norwalk, and that tends to be the easiest way to sort if there's a lot of people with your name. Remember, sometimes people misspell names, so it's easiest to look up just your last name with your first initial to start off with, and then sort through that way. Do not necessarily trust the mail. First off, you're going to get a mediation date. That will be a chance to meet with a housing mediator where you can try and work out a deal with the landlord. They're doing those internet right now. If you do not have internet access, we have talked to the library. They're willing to work with people who can check out, you can either check out a laptop with a Wi-Fi hotspot and use that. You can make an appointment to use the library computers, and they understand it's going to be a hearing and will be a little noisy, and they'll work with you on that.
Okay.
Or if you have your own phone, just not reliable Wi-Fi, you can just stand outside and use their Wi-Fi. Okay. So the library is already aware of this issue and willing to work with people who have any issues with connections. And I've talked to them, and they're being very good about that, which is much appreciated.
Fantastic. Yeah.
Even though it's going, they know it's going to make noise, and they're still willing to do it. So blessings upon them. Housing mediation is not a place for you to prove yourself right or wrong. Housing mediation is a place for you to try and make a deal. So what you want to think about going into housing mediation is, what is your best case offer? What is your worst case scenario if you don't make a deal? And what are you willing to live with? And think about that in advance, because the more you've thought about how much you can do and how much you can live with and what you can't live with in advance, the better your chances of doing well in housing mediation are going to be. The housing mediator is there to help, but if you go in with a list of grievances and no requests, it's going to be a little bit hard for them to help you make a deal, because they're there to help you mediate. They're not there to decide who's right and who's wrong. If you make a deal with the housing mediator, it will become a court order. If you break the deal you've made with the housing mediator, for instance, you make a repayment agreement with the landlord, but then you can't make the payments, then the landlord doesn't have to go back through the full eviction process. They can go back to court and say, they broke the deal, can I evict them? And the court will say, okay. So make sure, again, that any deal you make with the housing mediator is one that you can keep. You should also be aware that making a deal with the housing mediator for some stupid reason negatively affects your credit. An eviction also negatively affects your credit. So once you've reached that point, you're pretty much in a negative credit effect no matter what, unless you win an eviction case entirely. But it still can be a good opportunity to make a deal with the landlord, even if you weren't able to make a repayment agreement out of court. And repayment agreements out of court, those are better. So if you owe money with to the landlord and you start having income again, talking to them to make an agreement about paying a little extra each month until you've paid what's owed, that is your best route if you're not eligible for the federal assistance, which is coming. And if you can't get, if you are undocumented, you may also want to talk to the Connecticut Institute for Refugees and Immigrants, which I've referenced a lot, which has helped for undocumented people who are behind in the rent. If you can't make a deal with the housing mediator, then you'll have a hearing. Right now, I think those are also online, although I hear they are starting to resume in-person things relatively soon. Although for that, they're probably going to be prioritizing criminal, not housing. So again, if it's online, make an appointment with the library. If you don't have the tech access, the library will work with you on this. If you have a hearing, you want to get all your evidence together. So if you are claiming that the landlord didn't make necessary repairs, bring pictures. Get copies of the health department records. Make sure you submit all that to the court as in whatever manner the court wants you to submit it, so that you can show the judge, hey, look, it's actually this bad. In the hearing, you'll present your case, the landlord will present theirs, the judge will decide what should happen. If the judge decides you should be evicted, you will have 5 days to apply for what's called a stay of execution, which means more time to stay in the apartment. The judge has the power in a non-payment of rent case to give you up to 3 more months to stay in the apartment, but you have to pay all the rent that's owed and pay rent for the 3 months. In a case where the landlord is evicting you, not because you haven't paid rent, just because they don't want to rent to you anymore, that's called a lapse of time case. The judge has the power to give you up to 6 more months to stay in the apartment as long as you pay rent. I say the judge has the power to. That doesn't mean the judge will, it means the judge can. And that's the point at which the judge can take into account things like, you're old, you have children, you're going to have trouble finding a place, and say, yes, I see this. Equity says that you should have some more time, and the judge will decide how much more time you need. So it's not a guaranteed 6 more months. It's a possible. And how much time you actually get depends on the judge. Once whatever time you get is up, then you will get a 24-hour notice on your door. At that point, then you need to gather all your important stuff together, because if you're not out in 24 hours, a marshal is going to come in and they will take all your things and put them in storage. You can get your things out of storage by paying the storage fees within 15 days. Practically, I suspect they keep them a little longer, but statutorily, 15 days is how long they're required to keep them. At no point should your landlord be doing any of this. It is always going to be a marshal. If the marshal comes and takes your stuff out, so will you be out. So if you get a notice to quit and you think you're likely to lose an eviction, you need to call 211 for shelter placement early on in the process. Because as soon as you have the notice to quit, evictions have begun, and that is a better point at which to be placed in the shelter if you're not likely to win the eviction. Because if you move out before the hearing date and you go to court and you tell the judge, hey, I've moved out, then the judge will dismiss the case, which means you will not have an eviction on your record. So it is very valuable, if you're going to be able to move out prior to the hearing date, to move out prior to the hearing date and then show up to court on the hearing date and let the judge know that you've moved out, so that you do not have the eviction on your record. And that applies either for homeless shelters or for if you can find another place or move in with family or whatever you need to do. If you're going to lose and you're able to move out, and some people are and some people aren't, the eviction process buys you some time sometimes, then make sure you let the court know once you've moved out. If you don't let the court know, even if you have moved out, then you just don't show up, you can get a judgment against you for not showing up, and that will still show up as an eviction on your record. So those are pretty much most of the things that I wanted to talk about. Again, the main thing I'd like anyone to take away from this is to call our office with questions at 203-854-7989. Call the health department if you ever have repair or utility issues at 203-854-7820. And call Margaret Sueb, the Fair Housing Officer, if you have issues of discrimination at 203-854-7820. And did you have any questions or things you think I haven't covered?
Yes, I have a couple, but you covered everything. So I think they're more into the specifics of what you talked about, the walkthrough, the photography. Is there any preferences versus photo versus video, or both? Because people have asked me, is it better that I take video? Sometimes, like, my landlord says that, like, I Photoshop the images. So does it make any difference?
Judges tend to be more likely to flip through photos than they are to watch a full video. Okay. So I recommend, like, if you're worried about the landlord saying you Photoshopped it, also take video. It can't hurt to have both. But no matter what you do, have photos. And if you've only taking a video, take screenshots of the video.
Yeah, that's really, really good advice, because they did ask me that. And then I think, let me see, fictitious versus illegal. Oh, yes. So I get asked also a lot about like illegal apartments. Like, as a renter, how do I find out if the apartment that somebody's offering me to rent is like an actual legally allowed? I mean, the landlord is legally allowed to rent it, because they don't know.
I think there's no certain way to know except for calling the health department out.
Okay.
Here's some of the indicia. If it's a basement apartment with tiny windows, if you're living right next to the hot water heater, that tends to be an indicator that maybe this is not an illegal unit.
Okay.
You can look up the property address on the Norwalk City website.
Okay.
It's norwalkct.org.
Mm-hmm.
And it will tell you what the occupancy is.
Yeah.
So if you pull up the property card and it says that occupancy is 2 apartments, but you're in a secret 3rd apartment in the attic, well, maybe that's less likely to be an illegal apartment.
Yeah.
So that is, look for the things that tend to indicate it's illegal.
Okay.
Like small windows, basements are especially likely to be illegal. Check the property card. If you find yourself in an illegal apartment, understand that you're not the only one at risk. Because if the landlord rents out an illegal apartment, 1, you may not owe much rent on that. And 2, if the health department comes out and finds it's an illegal apartment and tells you to move, then you can go to the health department and apply for relocation assistance, which is help moving at the landlord's expense.
Awesome.
So the health department can put you up in a hotel at the landlord's expense. They can help you find a new apartment.
Okay.
They can pay moving costs and the difference in the rent up to $4,000.
Fantastic.
That doesn't mean they will pay the full $4,000.
Right. Up to, yeah.
Or things like that. That's all going to be something the health department charges the landlord for.
Okay.
Now, the health department isn't going to go, we will give you relocation assistance. You need to apply
for it. Okay.
But if you're in an illegal apartment and the health department finds out and orders you out, apply for relocation assistance. It is federally required, and the landlord's going to be the one in a lot more trouble. Okay.
Now, let's say somebody actually was in an illegal apartment. They did the process, they checked out, the landlord did not want to return the deposit. Because of the status of being an illegal apartment, do they still get to do the claims? Like, can they still file for a complaint, or it doesn't work if you're in an illegal apartment?
Absolutely, they can still file the complaint. And also, they may want to consider suing for the rent for the illegal apartment.
Fantastic. Oh, that's even better. Okay. Great.
They're not necessarily going to win that claim.
Sure.
But, I mean, the landlord is the wrongdoer in the case where a tenant is rented in an illegal apartment. So the tenant gets more rights, not fewer.
Yes. Yeah, no, that's excellent. So I think in a lot of cases, a lot of the people that may be going through these issues are already in there or have just left, and they had no idea whether it was legal or not. Maybe they did, but they may fear, filing anything because they think that they're going to be like liable for anything. So that's really good. Okay.
No, if the landlord rented out an illegal apartment, the landlord's the one responsible for that.
Okay.
The tenants do not lose any rights because they had the misfortune to have a landlord deceiving them.
Fantastic. No,
and
that's...
They may also be able to file complaints either for rent or under the Connecticut Unfair Trade Practices Act for deceptive practices.
Yeah.
They don't lose rights, they gain them.
Okay, fantastic. So, no, I think you honestly covered everything that I had on my list. I took a lot of notes. I kept checking stuff out. You did a fantastic job explaining this very simple, in a simple way. I will go ahead, once the recording is available, I'll send it to you. Mm-hmm. And then I will get that